the FTC had made a ruling to essentially ban all non-competes up to a certain salary threshold across the United States. Big deal. That ban was to go into effect in September, but a federal judge in Texas put a hold on it. What the judge was calling into question was the FTC's jurisdictional power to enforce such a ban. Why does the FTC get to have this ruling be followed by everyone across the country? Where's the power coming from? This lawyer sees both sides of it. I can understand how there might be a question of why they have the power to do this. It's a good legal question. It's probably going to go to the Supreme Court. So everyone who was calling me and asking me to review non-compete clauses, and I was telling them that could very well be null and void, all of that is on hold for now. I think it's a good idea to sort of do a little bit of a refresher on what we're talking about here so we kind of understand the implications. There's an overarching term for a company that limits what an employee can do after the employee leaves the company. We tend to call them restrictive covenant agreements, or RCAs. Those often encompass three main things, which is a non-compete, a non-solicitation of customers and clients of the former employer, and a non-solicitation of employees of the former employer. Let's talk about those two latter ones. What the FTC had not ruled on was whether non-solicitation agreements were going to be unenforceable. The best way I describe these non-solicitation agreements is you can't bring your book of business with you, and you can't poach employees from your old employer. With employees, it's, my ex-employer had a lot of good talent. There were a lot of good employees there. There were salespeople, there were marketing people, strategy, whatever, you name it, just really good at their job. And you'd think that they'd be a great asset at your new employer. So you call them up and say, hey, you should come over to my new job and they'll pay you well and you're really going to help us out. A lot of restrictive covenants have provisions that outlaw that. Only for a certain amount of time, right? It might be for like 12 months or 18 months after you leave that company. But you can't poach employees. You can't steal talent. And then the other non-solicitation is clients, customers. You can't take your book of business with you. So when I was younger and I was in law school, I worked at a 3PL selling space on trucks, freight. And I was a salesman. I made cold calls and tried to develop a customer base. Those weren't my customers. Those were my employer's customers. And if I wanted to leave to go to a different 3PL because they were going to offer me like better commissions or better salary or something like that, I couldn't take my existing customers with me. Even though they really were my customers, I was their sole point of contact at the company. And they really only knew me. I was the one that sold them that they should come work with my company, but there was no other interaction with anyone else at the company. They were totally my clients. However, my former employer would have argued the only reason you were able to get them as clients is because we facilitated it. We had a desk for you, we trained you, we taught you how to use our system, we had the computers and the phones, and it was really you selling our product that enticed that customer to come work with us. So you're not entitled to bring them wherever you want, they're ours, and we have the right to retain them. So that's really what a non-solicitation of clients and customers looks like. And it might even say something like, you can't take anyone we've been trying to get as clients, say, for like a year prior to your termination. The FTC really had no opinion about those. And in fact, I'm seeing a lot more of those. These non-solicits are becoming far more common. I don't care if you're an employer or employee, probably more fair. Don't stop a person who might have a family or dependents from not working in a field that may be their only field. If a guy sells cars, there's a good chance that all he knows how to do is sell cars. So if he leaves a company, he's going to go find another car salesman job. If you're essentially prohibiting him from doing that job, that's going to make life really hard. It's just not really equitable. And some of these non-competes, the scope of time is like 2 years, which here in Illinois, most judges would say was far too restrictive anyway. When you sign it and you walk away, you don't want to pay a lawyer or go to court to litigate out whether or not 2 years is too restrictive. Sometimes people just agree to it to the detriment of their own finances. Non-competes, they're restrictive, and and probably too much so. Eventually, they'll probably go away. And a lot of companies know that, so they're leaning more on these non-solicitations. The last one is a non-compete, which is just how it sounds. Let's say you worked in accounts receivable, so there's no real sales element there. You're just processing payments. When you sign a non-compete and you go work for another company in the same field and you're working in accounts receivable, you could be in potential breach of that non-compete because you are indirectly competing with your former employer, which is ridiculous, right? But that's what a lot of those contracts say. Normally, an employee is signing them at the beginning of their employment. They're not thinking about what it would mean to leave their employer. They just started with their employer. A lot of people aren't really paying attention when they're signing those non-competes. They may have a geographical scope. Nowadays, because of the internet, most non-competes geographical scope is the entire US. And if you work in an international company, it might even include some overseas territories as well. Then there's always a scope of time, which can be 6 months, 18 months, 12 months. It kind of depends on your title, the amount of money you make. But the one thing that is often overlooked, and the state of Illinois has really tried to kind of rectify this, is the idea that a restrictive covenant is still a contract. And there are always supposed to be these three elements that make up a contract: offer, acceptance, and consideration. It's different than a normal employment contract. You may sign an employment contract that says, I'll adhere to the policies of the company and the handbook, and this is what my pay will be. That may be an employment contract. A restrictive covenant contract is different. It's often a different document that you're signing. You're supposed to be given some consideration for it. When we talk about consideration, especially in the employment law world, we're talking about money. You're supposed to be given some money for you signing that. It's not enough that you get a salary, and so you're bound by this restrictive covenant. In the state of Illinois, they say, no, that's not, because it's not enough consideration. You know, when you get a salary, certain amount will go to taxes and deductibles and healthcare benefits, and then you're left with what remains. And if you're like anyone else, you're paying rent or a mortgage, and you're paying for your car and the everyday essentials. And then you might have some left over that you put in savings, and you might have some left over that you use to go out to restaurants, buy clothes, sort of the miscellaneous stuff. But we can attribute your salary to all of those things, right? Portion of that to this, portion of that to that. We're not attributing a significant portion of that salary to a restrictive covenant agreement. To consider that consideration for signing this restrictive covenant, it's just not enough that it's your salary. And here in Illinois, the courts have ruled that time and time again. For years, there was this court case, it was an appellate court case called Fifield, or that's what we all called it. And it basically says that proper consideration only exists after an employee has worked there for 2 years or more. And the idea being like, over time, each salary will attribute a certain percentage of it to consideration, and that proper consideration won't only really exist until a person has earned 2 years worth of salary. So then now that restrictive covenant agreement is enforceable. Of course, the alternative is for an employer to give consideration at the time of signing. Hey, here's $50,000. If you sign this, it is immediately enforceable. A company can always do that, but more often than not, companies will just try to kind of skirt along with this notion that your salary is the consideration. It's really not until you reach 2 years. Actually, last year in Illinois, it was codified in law. So now we don't really talk about Fifield anymore. Now this 2-year statute is law. By the way, the whole time I'm talking about this, I'm talking about non-competes, not really talking about the non-solicits. That is a little bit more unsettled law. We're talking about this ruling in Illinois. Most of the rest of the country doesn't have this unique 2-year requirement. If you sign and it's signed for nothing more than your salary, there's a good argument that it's enforceable right away. That just shows a level of inequity. Pretty good for the employer, pretty unfair for the departing employee. I would say that my tone is still cautious. I would not say for sure that this FTC ruling will be squashed and that this ruling won't go into effect. I'd say 50-50 right now. But in the meantime, a lot of employers, and I think it's right, and it's the advice I'd give, are sort of adjusting already. Because the way it's going, if it's this year, next year, or 5 years down the road, plan now. And frankly, I think it's going to help your future employees out. They're going to want to come work for you if you just have a non-solicit. If you have a non-compete, you might lose some talent because they're just not interested in it. So stay tuned. I have a feeling we'll be talking about this one for months, weeks, years to come.